That is when he put his hands on me as I was 32 weeks pregnant, that he was not able to get to me or harm me the way that he had when I was pregnant with my kid. Terrified that one day he's going to come after me and my daughter. I want him to be away for however long that can happen.
In one moment, Your Honor, our victim has invoked her rights under Marcy's law, so she's coming in now, so I wanted to wait for her to be present. Under my understanding is that the defendant will be changing his pleas from not guilty to guilty in these two cases, and that he would receive a suspended sentence in each case, 90-day suspended sentence in each case to be consecutive to one another. And there was some sentencing guidelines based upon, dependent upon his probation conditions out of a felony case that we had to look up, so we can speak to that once it gets to sentencing.
All right, and I see we are in compliance with Marcy's law with respect to having victim input, is that correct?
Yes, Your Honor. Ms. Snyder is present in the courtroom when the time is appropriate. She would like to address the court.
All right, thank you. Mr. Miranda, is that your understanding of this recommendation?
It is, Your Honor. My client has executed plea forms. We are ready to proceed.
Very well. Well, let's start with case 25 CRB 1212. In that case, the court does observe there has been a waiver of a jury trial that has been executed. It's been signed by you, it's been witnessed by your counsel. Furthermore, there has been a change of plea form from not guilty to guilty that has been completed. It's been signed by you, it's been witnessed by your counsel, Mr. Miranda, and all your initials appear in all the 6 boxes immediately adjacent to the matters pertaining to your plea here today. Do you understand all the rights that you're waiving by entering a plea of guilty to the charge of violating a protection order?
Yes, sir. Yes, Your Honor.
Is that what you wish to do this morning, sir? And Ms. Miranda, have you advised your client as to the consequences of entering a guilty plea?
Yes, Your Honor.
The court will accept your plea of guilty as being knowingly, voluntarily, and intelligently entered. Let's turn to 25 CRB 1018. Again, the court does observe that there has been a waiver of a jury trial in this matter. It's been signed by you, it's been witnessed by your counsel. Furthermore, there's been a change of plea form from not guilty to guilty from it's been completed. It's been signed by you, witnessed by your counsel, Mr. Miranda, and your initials appear in each of the 6 boxes immediately adjacent to all the matters pertaining to your plea here this morning. Do you understand all the rights that you're waiving by entering a plea of guilty to 2 counts of telecommunications harassment?
Yes, Your Honor, I do.
Is that what you wish to do this morning, sir?
Yes, Your Honor.
And Mr. Miranda, have you advised your client as to the consequences of entering a guilty plea?
Yes, Your Honor.
The court will accept your plea of guilty as being knowingly, voluntarily, and intelligently entered. Ms. Yeager, do you have any recommendation here on this?
Yes, Your Honor. So it was my understanding that the defendant was placed on a term of probation with our felony court for improper handling of a firearm. I'm not sure if he's still currently on probation for that, or if that term has expired. The telecommunications charges should at least, I believe, should carry a harsher penalty than we would normally request, because honestly, Your Honor, these should have been filed as felonies, because he has convictions out of Knox County that immediately preceded these charges for menacing by stalking and aggravated menacing and telecommunications harassment. All of this is against Ms. Snyder. While we understand he may have some services that he received under the felony probation that could have been beneficial to him. It did not have, since it was for the improper handling charge, it had absolutely nothing to do with interpersonal violence. So we would recommend that he be placed on a term of probation in order to address that issue specifically and be ordered to participate in whatever, I guess, our probation department deems appropriate as far as batterers intervention or anger management. He obviously has some issues with boundaries and controlling his own behavior and conduct, so we would ask for that. And then, of course, for Ms. Snyder's recommendations to be taken into consideration.
Before we get to Ms. Snyder, in 25 CRB 1018, there are 3 counts. I only have him pleading to 2. Are you dismissing the aggravated menacing count?
I didn't see that in
The menacing?
I didn't see that in the discovery that I got. I only had the two counts. That's all I could.
Yeah, I'm just, well,
It should be
he
a
was
third.
arraigned last
Oh, on
August
aggravated
27th on 3 counts, 2 counts of telecommunication harassment, and 1 count of aggravated menacing. Now, I'm just wondering if
I was not intending on dismissing, Your Honor.
you what?
I did not intend on dismissing.
So,
That counts. So I think it was inadvertently left off, just because these cases have been sitting around for a little while.
Mrs. Miranda, does,
That's not gonna change anything, Your Honor. I think
Well-
it's not gonna change it. We obviously need to explain that to the court. You had an act.
And, Your Honor, we would request that the court advise the defendant of the possibility of felony enhancement on
right,
these charges.
that's what I wanted to do. I want you to be aware that by pleading guilty to the charge of aggravated menacing under section 2903 I believe it's 31, no, is it? #21 of the revised code, that if you, it's an enhanceable offense, and the next time, if there is the next time, and we pray there isn't, it could be a felon. You do understand that?
Yes, Your Honor.
And knowing all that, you do wish to plead guilty to that charge as well?
Yes, Your Honor.
Very well. Quote, will accept your plea of guilty to the charge of aggravated menacing as being knowingly, voluntarily, and intelligently entered. Let's hear from the victim.
My name is Elisa Snyder.
You can sit if you want,
Okay.
whichever.
You
way
can
you
sit.
want.
Oh, yeah, and please, just speak up, because this old judge is deaf in his right ear, and I don't hear that well in my left ear,
I
so
gotcha.
if you just speak up.
During the time that I had spent with Valendag, he showed me how he could be one person and turn into a completely different other person. During the time like that he became an alcoholic, was drinking every day, and then as the months went on, I kept giving him chances and chances to be better, to be ready to welcome our daughter into the world, my daughter into the world, and he didn't show me that. And then he decided one day when I told him that I was done and I couldn't keep putting the stress, I couldn't keep taking the stress that he was putting me through while pregnant, 7 months pregnant, we decided to meet up, and we were at his grandma's house, and that is when he put his hands on me as I was 32 weeks pregnant, and I pressed charges a week after because I wanted him to just leave me alone, and he couldn't do that. He blew up my phone. He made 15 fake phone numbers to get a hold of me. Every call that I had answered, from the no caller IDs, the 15 fake phone numbers, and his own cell phone number, I would ask him to leave me alone, to let me have my space, give me my time, because he was just doing too much as I was going through being pregnant with hormones and everything else. When he was in jail for Knox County, after he put his ex through the exact same situation that he put me through, I felt relief. I felt that he was not able to get to me or harm me the way that he had when I was pregnant with my kid. I am terrified that one day he's going to come after me and my daughter. I want him to be away for however long that can happen. I'm sorry.
No, take your time.
I wish him the best, I really do. But I need him as far away from me as that can be possible.
Okay. Now, is he the father of your daughter?
Yes, he is the father of my daughter. We got married back in October. We knew each other for 2 months. It was a very not sure what we were thinking. And 2 months after that, found out I was pregnant. And he would stand in front of the door so I couldn't leave. He would jump in my car. He would not let me leave whenever I would be with him. I had filed for a CPO back in February because he called me in telecommunication harassment that time, and then I dropped it thinking that he would change, that since I showed him that I can put my foot down and that I deserve more and my daughter deserves more as a father, from a father. So then try giving him that chance. I gave him months to change, and he put his hands on me, and I knew that he could not be that it wasn't safe.
Do you presently have a CPO?
I do, and my daughter is added to that.
And I take it that's for 5 years?
Yes.
Okay. All right, is there anything else you'd like to state?
Would I be able to ask him personally a question? Like, would I be able to now or no?
You know, if you were going to ask him a question, you ask the court. What would that question be?
Why couldn't he change? I sat down with him and I would tell him what was happening and what he was putting me through and how it was not human. It was inhumane to put someone through the things that he did. And
Okay.
he continued. And I just want to know why.
Well, okay. Appreciate that. Mr. Miranda, what do you have on behalf of your client here?
Your Honor, obviously the court's been doing this for a substantial period of time. The court, I think, can garner from just these statements that we hear today. There's a lot of layers. We don't arrive here as a defendant. We don't arrive here as a victim unless there's issues on all sides to bring us here. My client's taking responsibility for his actions. He pled. There is a CPO in play. The grand reality of all these young parties, because they're both young, is they have a child together. And she can say it's her child, his child. They have a child together. So this is going to be a long, drawn-out process because there's a minor child involved. I've explained to my client that he needs to go through the domestic relations court to handle all visitations and things in the future, so it's handled appropriately, so that there's no issues with regards to the CPO, and then modifying the CPO down the road as the custody visitation issues work through the DR court. But nonetheless, one poor choice, one poor decision, 2 months into the relationship brought forth a new life. So now these two are going to be, unfortunately, linked for a period of time because they have a child, they have a baby. Client's 23 years old. He is employed full-time at Gearling Associates. I am asking the court to suspend the time. He is on felony paper. I had no objection to the consecutive sentences suspended. My client understands if there's any contact whatsoever, he's facing felony charges through the enhanceability of these statutes. So So he's gonna comply with that. Otherwise, Your Honor, just ask him for the suspended time so he can get back to work. He has served a substantial amount of time through the Knox County case, and he is on pretty strict protocols through the Licking County Common Police Court. Thank you.
All right, thank you. Mr. Dog, is there anything you'd like to state in your own behalf? It's not necessary, but you may if you wish.
No, Your Honor, I am contending for my lawyer as stated.
Well, I'm going to correct Mr. Miranda on one thing. He said this wasn't a one-time thing, was it? I mean, you got 2 cases, and I don't know how many other incidents there were.
Your Honor, if I may interrupt, I'm so sorry. I was just clarifying with Ms. Snyder, the issue in Knox County. He served a period of time in the Knox County jail for the same conduct against a different person as well. So it sounds like this has been a little bit longer of a pattern for Mr. Dagg.
Okay, and on top of that, I mean, look, this isn't the road you want to go down. I guarantee you, because it only gets worse from here. Now, you're on felony probation where? Here or
In Licking County.
in Licking County? How long you on probation for?
I will be off of it August 27th, Your Honor,
Okay, well,
as long as I get everything done, which I have so far.
yeah, I don't know what all your issues are, and I'm sure Ms. Snyder doesn't know what all your issues are. And I don't know that she wants to know, but she, as Mr. Miranda did say, you've got a child together. That's something that you're going to, you know, that's at least an 18-year commitment, and I want you to honor that commitment. So you haven't served any time as far as jail time here, is that correct?
I mean, I was in there for about 2 weeks in total, just overall going back and forth while I was in Knox, and then I spent about a week there for this case once I was done in Knox.
So is there 7 days credit here, is that correct?
I don't know if there is credit on these cases, because I know he did go a little bit back and forth with here in Knox, between his felony cases. When these were originally charged, the reason why he wasn't arraigned for so long on like the VPO was because he was incarcerated in Knox County. So it sat in warrant status for a long time, because he had to serve out that sentence before he could be brought here.
Okay, well, he was arraigned in August on the
first one.
on the 1018 case, and then arraigned on December
In the other
2nd.
one. Yes.
On the 12. Well, I'll tell you what, I don't know if that was felony time or this time. Here's what I'm going to do, just to make it simple for everybody. I'm going to make it in each of these cases, there's going to be a $100 fine, court costs. You have time to pay it, you don't have to pay it today. I am imposing a 180-day jail sentence in each of these cases to be served consecutively to each other. They will be suspended. Now, I know a little bit about math. 180 and 180 is 360.
Yes.
That's like a year.
That's, yes.
And I don't want to see you do that. I'm quite certain Miss Snyder doesn't want you to do that either. I think she'd rather see you support your daughter. And I don't know how else to say this, but get your act together. I mean, it sounds as though you've had some real issues, and I assume under your terms of your probation, there's no, or community control, I guess it is, no weapons, right?
No, sir. No,
Okay.
Your Honor. No weapons.
No weapons.
drugs or alcohol.
I want you to follow the CPO. I think that's also something that I can order. And my friend, make certain that you're getting the help you need, for not just for your sake, but for your daughter's sake, for Mrs. Snyder's sake, okay?
Yes, sir.
Anything further?
No, Your Honor, thank you.
All right, good luck to everybody.
Thank you.
All right, and then I
And
have
good
the-
morning, today is March the 30th of 2026. This is the Licking County Municipal Court. I'm Judge David Landefeld. I'm a retired judge sitting by assignment of the Ohio Supreme Court. Our first matter here is Village of Buckeye Lake versus April Swick. And you're Ms. Swick, is that correct?
Yes.
And Ms. Swick, you're represented here today by Attorney Zachary Miranda. Good morning, Mr. Miranda.
Good morning, Your Honor.
It's my understanding that your attorney and the state have entered into an agreement whereby, Mr. Nicodemus, why don't you state that on the record?
Thank you, Your Honor.
Right.
Yes. She's been charged with OVI. OVI per se is speed in a lanes violation. This falls really close into the 10-year look back. So upon a plea today, the state would ask the court to proceed as if this were a first offense in 10 years with high test. So it would be 3-day dip, 3-day jail instead of a second offense high test penalties.
Is that your understanding of this recommendation, Mr. Miranda?
It is, Your Honor. I've had an opportunity to discuss that with my client. She has executed the necessary jury waiver and plea forms. We would stipulate to the facts sufficient for a guilty finding to the charge.
All right, thank you. Ms. Swick, the court does observe that there has been a waiver of a jury trial that's been signed by you, witnessed by your counsel. Ms. Miranda, the court accepts that. Furthermore, there has been a change of plea form from not guilty to guilty that has been completed. It's been signed by you, it's been witnessed by your counsel. And your initials appear in each of the 6 boxes immediately adjacent to all the matters pertaining to your plea here today. Do you understand all the rights that you're waiving by entering a plea of guilty to the charge of OVI?
Yes.
Is that what you wish to do today, ma'am?
Yes.
Very well. Mr. Miranda, have you advised your client as to the consequences of entering a guilty plea?
Yes, Your Honor.
Court will accept your plea of guilty as being knowingly, voluntarily, and intelligently entered. What do you have on behalf of your client here, Ms. Miranda?
Just briefly, Your Honor, client's 47 years old. She works in Newark High School. Your Honor, this is an isolated instance. She is extremely remorseful for her actions. We would ask that the mandatory minimums, as we discussed, be imposed with regards to 3 days of actual jail time that she needs to serve. We would ask for a report date on that so that it doesn't affect her job within Newark High School.
All right, thank you. Ms. Swick, is there anything you'd like to state in your own behalf? It's not necessary, but you may if you wish.
Yeah, I know it's not necessary, but I would like to say something. I've struggled with addiction most of my life, and I just lost my husband and my mother, so it's just been a very difficult time for me, and I'm very grateful that I'm not doing 20 days in jail.
Okay. Well, I mean, this, you're fortunate here.
Yes.
It could have been a lot worse.
Yes.
And obviously, it could have been a second offense in 10. And I obviously I don't want to call it an isolated incident because you kind of have a history. And I don't want to see that history continue. And I hope you don't want to see that continue, because it's just going to get worse and worse for you. Well, I'll tell you what we're going to do. It is a first offense. We're treating it as a first offense within 10 years. In terms of the OVI, I'm going to we don't want probation on this, do we, or do we? Mr. Nicodemus?
Well, I mean, since there'll be some time available, probation will be involved. Usually we just leave probation terms up to their discretion. They'll do an assessment and determine if there's any additional follow-up services needed.
But you do want her to be on probation, so you want the jail term to be longer than...
Then just the 6 days?
6 days.
Yeah, usually we do like 30 days to spend the rest.
Okay. Well, I'm going to make it a 30-day jail sentence, which is pretty low. You'll be on probation for 1 year. Look, you're going to be under the supervision of the probation department, and they will assess what you need to do. You can do 3 days of jail and 72-hour. Let's see. When are you to report? Do you have a report date?
Today's March 30th, so we can do it in. Yeah, three-day jail. Yeah, you can do it like Friday, Saturday, Sunday.
Oh, it doesn't matter.
No, it doesn't matter, just tell us.
How about,
April 17th, 18th, and 19th, Your
yeah,
Honor.
that'll work. Yep.
Okay. So you're going to report on April 17th. And what time?
8 a.m. here, Your Honor.
8 a.m.
We can do 9.
Or 9? Okay, 9
Yes.
a.m.
9 a.m.
Yep.
All right. And as I said, you can do three of those days you can do as a driver intervention program. I want you to undergo a drug and alcohol mental health assessment and successfully complete any treatment or counseling that is recommended. Now, let's not be drinking, okay?
I haven't.
All right, but if you're on prescribed medication, you can take that, but take it as prescribed and only as prescribed. I am going to impose the minimum fine, which is $565 for this. Now, when did this occur?
January 31st.
January 31st. Okay, I'm going to make it a 1-year driver's license suspension. And I'm going to make that effective January 31st, okay? Getting a little bit more of a break here. Now, I don't know, does your client have driving privileges at this point?
No, Your Honor.
Okay. And I'll be up to Judge Stansberry. If you have a valid license and you maintain insurance, you can most likely get limited driving privileges. Now, with respect to the other 2 charges, I'm going to make it another $25 fine for the speeding violation and another $25 fine for the driving in marked lanes violation. And so that's $50 more, so now we're $615, okay? Well, this may not be okay, but that's what it's gonna be. And the only thing I can tell you is, be careful out there. We don't want to see you back in here, and I know you don't want to be back in here, but you gotta be careful, okay? Good luck, man.
Billy Mayfield.